Now for our distinguished panel of speakers for today's program. First, James Hanft is a partner with the New York office of Darby & Darby. His practice focuses on patent counseling and litigation, but also extends to trademarks, false advertising, licensing, and the obtaining of patent protection for inventions. Next, Dan Stowell is the director and editor of the Papers of Abraham Lincoln. After joining the staff of the Lincoln Legal Papers in 1996, he became the director in 2000 and managed its expansion into the Papers of Abraham Lincoln. He is the author or editor of 5 books, including The Papers of Abraham Lincoln, Legal Documents and Cases, 4 volumes, 2008, Rebuilding Zion, The Religious Reconstruction of the South, 1863 to 1877, and In Tender Consideration, Women, Families, and the Law in Abraham Lincoln's Illinois. Third, Scott Peering is an attorney with Cargill Incorporated, a global corporation focusing primarily on the agribusiness and nutrition areas. Mr. Peering's practice focuses on intellectual property law and counseling, including patent, trademark, copyright, trade secret, and intellectual property litigation matters on a worldwide basis. Thanks very much. Jim?
Thank you. Good morning. I wanted to give a little bit of a background of what we're going to do today. We're going to start out, and Jim is going to lead off a little bit and tell us about the evolution of patent law in the United States up until Mr. Lincoln tried to get his patent. So walk us through how we saw things evolve, what the policies and practices were behind them. Next, Daniel will lead us through what is truly the key reason we're here, and that's Mr. Lincoln's patent. We'll talk about what the patent is and some little color around why it was out there, and maybe a few other things about Mr. Lincoln's law practice in the intellectual property area. I will then try and bring us up to date and talk a little bit about how the law has changed since then. If you have questions at that point, please, there's a microphone in the middle, step up, ask away. After that, we'd like to talk a little bit about how Mr. Lincoln's patent would be viewed under some of today's standards. And again, that's where we would really encourage you to help us on that. Add your input, add your thoughts. Certainly, you all have expertise as well, and we'd love to hear it and hear your thoughts on this as well. With that, Jim,
Thanks,
take
Scott.
it away.
As you said, I want to step back and talk about a little bit about the history of patents and kind of bring us up to date, as not up to date, but up to 1849 when Lincoln got his patent. So it kind of sets the format for his presentation, and you can put it into context and understand exactly what the Patent Office was about, what the patent laws were about. And going through this, I'm not an expert in history, but I found it absolutely fascinating to walk through and see how things developed in the past and how they affect the way that things have occurred in the development of law up to the present. Patents originated in Europe. They were monopolies granted by the royalty in Europe. It was basically a royal prerogative to grant monopolies. And one of the reasons, they did it for multiple reasons. One, perhaps to fill the coffers of the royalty or to bestow favors on some of their more favored subjects. But what they're really trying to do was to bring foreign trade. For example, in England, one of the mandates was that if you bring in a foreign trade that doesn't exist in England at the time, a monopoly would be granted to you so that you could bring that trade to England. And it was a way of increasing the economy of England. Problem with granting monopolies to favored subjects is it was subject to a lot of abuse. So, as an example, there was one of the earliest known cases, Darcy v. Allen, in 1602. There was a patent on trading cards that was set aside as not being new. The result of all of these abuses was that in 1623, and I know I'm talking about ancient history and I'll come up more to the present very quickly, the English Parliament passed the Statute of Monopolies. That essentially limited patents to a 14-year limit and had judicial review of patents. From patents during this time frame, to give you a kind of some idea of the volume of patents and how many it issued, from 1680 to 1780, only about 800 patents had issued. Now, early on, those patents were just kind of the crown saying, well, you've got it in this area. The requirement of a patent having a specification where it details exactly what the invention is, that began early 1700, in 1712. That was the earliest specification of a patent that existed. Now, during this time frame, obviously England had settled the United States, and before the Constitution came into existence, the states granted patent rights. The earliest patent was in October of 1634. The first patent was granted by Massachusetts to Samuel Winslow for a method of manufacturing salt. So we're not talking about a history of 100 years or 150 years. We're talking about a history of 400 years. You know, patents in the United States are 350 years. Patents in the United States. So during that time frame, up until the Constitution, states had issued the patents. And you can see what the problem with that was. If one state issues it, doesn't mean that it can be enforceable in any of the other states. Constitution comes around. The US Constitution, it was around 1787. It was ratified. I don't know whether it was 1787 or 1788, right around there. But Article 1, Section 8 provides Congress to have the power. Now, you know, it's funny because, you know, you read this in law school, but then, you know, you kind of don't read it again after you begin practicing. But it's interesting to see that Congress shall have the power and to promote progress of science and useful arts, securing for limited times, so it always has to be limited times, authors and inventors, the exclusive right to their respective writings and discoveries. And it occurred to me as I was reading this last night, an exclusive right. So, you know, I kind of question in my mind, you know, we're changing the patent laws these days and saying, you're not allowed to, you know, perhaps we should have some type of a compulsory licensing. That, well, does that fall in with what the US Constitution says, that they get the exclusive right? So I was just starting to think about some of this stuff and seeing how, you know, perhaps there might be some challenges to some of the issues that are being raised today. The provision for patents, and this obviously applies to copyrights as well, it was proposed by James Madison. It wasn't in the first draft. It didn't come until later and was submitted to a committee which was composed of all of the different states. Once the Constitution was ratified, well, it still doesn't have any force. They had to do patent laws. So in 1790 was the first patent statute. There were 7 sections in this initial statute. The bill was inspired and urged by Jefferson. It limited patents to 14 years. And what was interesting was, for patents to be granted, you basically had to have review, discretionary review by basically three different individuals: the Secretary of State, the Secretary of War, and the Attorney General. Now I'm thinking to myself, how are they reviewing all this stuff as they're running the country? But obviously different times from them. The statute allowed them to reject for novelty or insufficiency of importance or utility. The result of having this process of having to go to these 3 individuals, they did quite strict review. In the first year, only 3 patents issued. The following year, 33, then 11, and then in 1793, only 20 patents issued. There was a lot of people were not satisfied with this procedure and what was happening. Just kind of, I was curious. I went through this and I was trying to think, you know, I wonder what the first patent looked like. Here it is. I'll get to in a minute why